All right, Ted Rowland's at the courthouse. Let me bring in my think tank tonight. Joining us in Orlando, the Honorable Belvin Perry, the former chief judge of that courthouse in the 9th Judicial Circuit down in Central Florida. Also with us, juvenile court judge Ashley Wilcott, criminal defense attorney Michael Sterling, and criminal defense attorney Jasmine Barber. Welcome to you all. Let me begin in Orlando with Judge Belvin Perry. Judge, during your time as the chief judge down there, did you ever have a situation quite like that where the power just went out in the middle of a death penalty case?
Vinny, that has never happened to me. I've never heard of that happening in the courthouse. This is the first occasion.
All right, and Judge, do you think that how would you as a judge deal with that situation? You've got a jury in there, you've got a criminal defendant charged with murder sitting very close to the jurors, and all of a sudden the power's cut out. What are the concerns there?
Well, number one, if the power did not come back on within 5 seconds, the first thing you need to do is excuse the jury and have them taken back to the jury room until you're able to find out. The next thing you would do after you got power back, you would want to inquire of that jury whether or not anything happened during that recess that would affect their ability to be fair and impartial. You want to make sure that none of the outside events, i.e. the power going out or the smell of smoke, caused anyone not to be able to carry out their duties.
All right, let me go here in studio, and this is really a bizarre moment. Death penalty case. We know someone at some point is going to look over the whole thing with a microscope if, in fact, there's a conviction and a death sentence. But Judge Wilcott, your thoughts about a blackout in the middle of testimony, in the middle of a death penalty case?
Okay, so it is unusual, right? A fire alarm's gone off in my courtroom, and I think you have to do the exact steps Judge Perry just outlined. You also have to first make sure that the defendant is secure, because you don't want the jury to ever feel afraid or fearful or that they're traumatized by the event. So you have to secure the jury, secure the defendant, and then you do have to address it after the fact. It happened, it's how you respond that's important.
And you know, Michael, one of the things, you know, the defense attorneys go at lengths to make sure that the jury doesn't see their client with shackles or handcuffs or in orange suits or unshaven or unfed, whatever, especially with this criminal defendant. But here, at that moment, you know, security had to kind of surround him a little bit to keep everyone safe. Is that a problem?
I mean, it could be if someone said something that was inappropriate. Obviously, you expect the bailiffs to do their job to keep everyone safe. But if someone had said something, if the judge, you know, had made a slip of the tongue or someone had said something like, hey, secure the defendant, they said it out loud. I don't know if the court reporter was still able to take record with the lights off, but if that happened and the court reporter was not able to get it on the record and you had witnesses there, you'd want to get affidavits. So you'd want to go through the process. If you're the defense attorney, your number one priority is defending your client. And if someone said something inappropriate that could have impacted that trial, particularly in a death penalty case, you'd want to make sure, whether it's the court reporter, if her machine went out and she couldn't record it,
I think it did.
You'd want to get affidavits.
In the middle of the blackout, the judge actually said, asked both sides if it was okay to go off the record as they sat in the courtroom in the semi-darkness. That's just a bizarre moment.
I mean, what choice did they really have with a blackout, no power, no court reporter? I mean, you have to go off the record, but as a defense attorney, I would always demand that once we did regain the power, that we put everything that happened while the power was out on the record.
You know, it's interesting, Judge Perry, Judge White in this case decided to stay, went back on the bench and was kind of on the bench with everyone else, with the jury in the jury room, waiting for the power to go back on. Would Judge Perry have stayed on the bench?
No, sir, I would have gone back to chambers, or I at least would have waited outside until we can determine when we would be back up. Let me add one thing. The stenographic court reporters in Orange County Courthouse, all of their machines are also battery powered. So depending on whether or not they were fully charged up and operating on power, they have the ability to continue to take down whatever was being said in the courtroom.
Yeah, and hopefully they did. At some point they did go off the record, but before that I'm sure they were on the record. And then you have another moment here where you've got firefighters all of a sudden entering the courtroom because of the smell of smoke. My whole concern here is just jurors getting a little distracted from the facts of the case.
Absolutely. Not only that, but again, they're going to be afraid. What if some of them have experienced a fire and that makes them think about that instead of the trial? That would be my biggest concern as a judge, and I too would want to have all of the jurors in to be questioned to ensure it doesn't affect their ability to be neutral and deliberate in this case.
The other thing that surprised me, this is a criminal defendant who's written, and I'm showing these to the folks at home a bunch of times, a bunch of letters that are really somewhat bizarre and strange. Yet, during this whole thing, he didn't do anything. He kind of sat there and didn't create a scene. Are you surprised by that, first of all?
I think he's demonstrated that he is a defendant that is completely and totally unpredictable. So when you expect him to make a scene, he doesn't, and then when you don't expect him to make a scene, he does. So I don't know if his lawyers are doing, providing the appropriate guidance for him, and that's why he.
That's if he listens to them, though.
Right.
I'm sure they are. The big question was whether or not he was going to listen to them.
Exactly, but he's demonstrated that he's completely and totally unpredictable.
All right, folks, our 13th juror question is about the defense team, and they've made a decision here to do very little cross-examination. Is that a good strategy here during the guilt phase? Go to the CourtTV Facebook page or Vinnie Politan Court TV. Let us know, yes or no.
This week in Court TV history, 20 years ago, on June 25th, 1999, Scott Falater was convicted of first-degree murder. He was prosecuted by Juan Martinez in Phoenix, Arizona. Falater took the stand and admitted to killing his wife by stabbing her 44 times and then drowning her. But he said he didn't remember anything because he was sleepwalking when he did it. Investigators said he knew what he was doing, even hid his blood-stained clothes in the trunk of the family car. Falater was sentenced to life in prison without parole this week in Court TV history.
All right, Scott Nelson is a little bit different than most criminal defendants. He's been, if we looked at his interrogation video, and he seemed very relaxed and sort of preoccupied with food, not really concerned about the long-term impact of giving information to investigators, more concerned about the short-term impact on his hunger. One of the other things that's been interesting about him in the courtroom is that we've expected perhaps some sort of outburst, but nothing has really happened except two instances. One happened yesterday, where during the opening statement of the prosecutor, she was describing how Jennifer Fulford, the victim in this case, was bound with duct tape, and at that point pointed directly at the defendant. And when she did that, he turned and looked at the victim's family in that direction and gave him a wink. Well, today it happened again. A second wink in a really disturbing moment where the court is getting ready to talk about autopsy photos and what happened to Jennifer Fulford. Ted Rowlands was inside the courtroom and again saw Scott Nelson wink towards the victim's family.
He did it again. He winked at in the direction of Jennifer Fulford's family. He turned around and winked. We reported this yesterday that it happened during the opening statements where when he was basically introduced by the prosecutor and accused of killing Jennifer Fulford, he turned and winked at the family. He did it again today. This time, it was when we were getting prepped by the judge that the next witness was the medical examiner and that there were going to be autopsy photographs. And there I'm sitting behind him again, and he does it again. He turns and winks. And this time, the liaison that's appointed by the court to basically be with the victim's family at all times helps them with the proceedings. She saw it. I talked to her outside the courtroom, and she said, yeah, oh yeah, I saw it. He stared right at us and winked. She told the bailiff, who told the judge, and the judge then informed Nelson's defense team at a sidebar, and immediately after that sidebar, Chelsea Simmons on the defense team went and talked to Nelson, and I could see Nelson nodding his head. I don't know if he was saying, yes, I understand, I can't do that, or yes, I did do that. I don't know what was being said, obviously, but he nodded his head, and that was that.
Now, if you recall, the layout of this courtroom, again, has the defendant next to the jury. So when he turns towards the victim's family and the prosecution side, you can see he's turning away from the jury. So they wouldn't necessarily see the wink, but the wink not intended for them. The wink clearly in the direction of the victim's family and the prosecution. Let me bring back in my think tank and Judge Belvin Perry with us down in Orlando. Judge, what type of instruction would you give to the defense, being informed that the defendant during moments like this is sort of antagonizing the victim's family?
Number one, there's a standing administrative order prohibiting anyone, including the parties, the attorneys, from doing facial gestures. Remember, Mr. Ashton got in trouble for that in the Anthony case. He was just basically, in my estimation, trying to evoke a response from the family of the victim that may have caused them to react, and he may have garnered a mistrial.
Yeah, it seems that may have been what he was thinking of doing here. So what does this tell us about this criminal defendant?
I agree. He's unpredictable. We don't know what he's thinking or what he's going to do next. It's fascinating to me because he does things that you think, what's next? It's almost fun to watch and see. Not fun. It's a death penalty case. I don't take it away from that. But what's next? It's fascinating as a study of a character.
I mean, he reminds us of the narcissistic characters along the lines of a Ted Bundy, who just, they cannot accept responsibility for their actions, and they continue to antagonize, and they're bodacious and they're braggadocious about, their crimes. And I think he sort of reminds us of those long line of characters who are some of the worst criminals in our history.
Jasmine, based upon what we've seen him do so far and these letters that he's written, what does that tell us about what he might be like if he decides to take the stand?
I mean, as a defense attorney, I would be very nervous to put him on the stand, not knowing what he wants to say. He's obviously willing to divulge information that is not necessarily beneficial to his interest. And so that would make me incredibly nervous. And then obviously his demeanor in the courtroom, that's something that we are constantly coaching clients about doing. Like, you have to control yourself while this jury is very closely watching you.
Yeah, it seems to me he's uncoachable, though, and unpredictable, uncoachable. If he took the stand, do you think he would take credit for what happened to this poor woman? Do you think he would take credit and sort of brag about this thing on the witness stand?
That's the unknown. That's the problem with a defendant like this. He might, Vinny, and if he does, well, then game over. So there's no telling what he might do on the stand.
Good lawyers like to know what's going to happen in the courtroom before it happens, and putting him on the stand takes away that ability from his defense lawyers. It's, again, unpredictability. You don't want to put him on the stand because it's going to take away your ability to know what's going to happen next.
Judge Perry, if in fact he takes the stand and, I don't know, starts taking credit for this gruesome murder, does he just have to be permitted to go on and on and on, or can a judge do anything to control what he says and how he says it if his purpose is to antagonize the victim's family?
As long as he's confessing to the crime or saying something germane to his case, barring some objection, the judge will let him ramble on for a while. If he starts going too far afield and starts lobbing insults to the family or lobbing insults about the victim, the judge will put a stop to that. More than likely, Judge White will recess for a moment and give the defendant some instructions outside the presence of the jury.
Yeah, and this has to be a concern for everyone involved in the case. Even the prosecution has to be concerned because, again, it's a death penalty case. You don't want to have to do it over. You want to dot the I's, cross the T's here. So any concerns here, even from the other side?
Yeah, you want to make sure that something doesn't happen that impacts what could potentially happen on appeal. And so you know that in a death penalty case, if the jury chooses the death penalty, it's going to be appealed and appealed and appealed. There's going to be countless appeals, and so you want to make sure you protect and preserve the record. So if someone as unpredictable as him gets on the stand and prosecutors react a certain way, if things happen differently than anyone anticipates or expects, you could have grounds or basis for appeals that can go on, for many, many years.
And this is a defendant that is somewhat sophisticated, having served all these years in prison. I'm sure he spent some time as a jailhouse lawyer looking up these issues and kind of knows what's going on.
Absolutely, and I again would be concerned, what if he does provoke a family member? Gosh forbid a family member reacts publicly in court during the trial. That's certainly good grounds for an appeal, and he knows that. I think to an extent he's playing a game with what he's doing.
Especially if it happens in the presence of a jury and somehow bias a juror, or a juror says, hey, I was biased by this family member. Lawyers are going to go get affidavits from the jurors to try to get some grounds for appeal, and that could have an impact. And so, to Judge Perry's point, you want to make sure the judge keeps a tight control and tight lid on what happens.
All right, our 13th juror question. The defense not doing a lot of cross-examination. Is their decision to do very little cross a good strategy? This is the guilt phase. There's still another phase. If he's found guilty here, then it's the penalty phase. So is this a good strategy? Yes or no? Let us know on our Facebook pages. Tomorrow night, Mark O'Mara, George Zimmerman's former attorney, joins us exclusively to talk about Florida v. Nelson.
This is the evil part of it all.
A Florida man stands accused of abducting a nanny from a Winter Park mansion and then killing her.
The murder was an especially heinous crime.
Prosecutors are seeking the death penalty for Scott Edward Nelson.
I'm just curious to know where this is all headed.
It's going to be a very dramatic trial because there is a mountain of evidence against Nelson.
I'm a Winter Park resident, and my nanny is missing.
A 911 call signals the first sign of trouble. Jennifer Fulford, a nanny who's been working at this upscale Winter Park, Florida home, failed to pick up one of the children she was caring for. Her employer, a single father who's relied on Jennifer for the past 6 years, is worried and reports her missing.
This is what's unusual, is her purse is here.
Okay.
Her car's gone, her purse is here, and nobody's heard anything from her since 11.
The call sets off a desperate search and a plea on Facebook for information from Jennifer's husband. Jennifer was excited for an upcoming trip to Dallas to meet her grandchild, who was born earlier that day. Surveillance video captured Jennifer leaving this dentist's office the morning she disappeared. It would be the last image of her alive. 3 days later, police recovered Jennifer's body from this wooded area. Investigators say she had been stabbed and suffocated, her wrists and ankles bound, her face covered with duct tape. Police quickly tracked down her alleged killer after he withdrew $300 from Jennifer's bank account using her ATM card.
You have the right to be signed, you understand that?
Scott Edward Nelson was arrested and questioned by detectives.
And I did what I had to do to survive.
Nelson would make several incriminating statements and offered some insight into why he may have made Jennifer Fulford his target.
I wasn't particularly happy with this. Sure. See, these people in Winter Park, for instance, right? They have everything by the They have beautiful homes and beautiful cars and golf courses. I'm walking down the street while all these rich people are walking around buying jewelry and they're having their good life and all this stuff. I wouldn't give a rat's about me.
At the time of the murder, Nelson was homeless and an ex-convict. Among other crimes, he had served time in federal prison for bank robbery. Now, Scott Nelson faces kidnapping and first-degree murder, charges that could mean the death penalty if he's convicted.
Investigators in this case really did a great job in tracking down all the evidence, and there is a lot of it, and they're presenting it pretty quickly inside the courtroom. Today we saw videotapes, and they're able to track the movements of Scott Nelson through these surveillance videos. The first one I want to show you is at the Amtrak station, and prosecutors say this is after the murder. He's seen there changing clothes. And you see the top right of your screen? You see he's changing clothes there, which again shows, okay, this is a guy trying to elude police, right? If he's changing his clothes from the time he was wearing them at the time of the alleged abduction that he's guilty of, and at times where he's at the ATM as well. The next video, you have Scott Nelson, again, his obsession with food. Here he is at a local 7-Eleven. If those of you don't know what 7-Eleven is, it's a convenience store. You know, you can buy things like pizza. And apparently, Scott Nelson goes to the 7-Eleven here, and there you see him getting a box with some pizza. Next video, you see him again back at the Amtrak station here, where he's disposing of some items, a plastic bag and a duffel bag in the trash can over at the Amtrak station. So really a great job by investigators. I want to show you some of that testimony. Kai Sullivan works for Amtrak as one of the officers there and was able to explain to the jurors all the videos that they were able to retrieve to track the movements of the defendant.
Can you please tell us how you are employed?
I am a detective with the Amtrak Police.
Okay, I gotta say, I didn't know that Amtrak had their own police force. So if you could tell us, are you a federal employee? How does that work?
We're quasi-federal, where our authority comes from Congress, but we enforce state and local laws.
Okay, so you're the cop on a train?
Somewhat, yes.
Okay, all right. And how long have you been doing that?
I've been with Amtrak Police since 2009, September 27th, 2009, in patrol and then sergeant, and as of January 1st, 2016, detective here in Florida.
All right, and what is the area that you cover? What's your jurisdiction?
I cover all of Florida and all of Georgia.
Okay. Now, I want to show you what has been marked for identification. Can I approach you?
Yes.
I'm going to show you what's been marked for identification as State's Exhibit Q. Okay?
Yes, ma'am.
And do you recognize that item?
Yes, this is an Amtrak ticket.
It's an Amtrak ticket, okay? And is there something that you can tell us? Can you tell us how this Amtrak ticket was purchased based solely on what it looks like?
Yep, these tickets you have to get from a ticket counter.
So a ticket of that nature, it can't be printed online?
No.
And it can't be bought from like a machine?
Only in D.C. and New York, up on the north, but not down here. Nothing south of D.C.
Okay, so down here in Florida, that ticket that you have there in your hand had to have been purchased at an Amtrak ticket counter?
Yes, ma'am.
Meaning in person?
Correct.
All right. Can you tell us by looking at that ticket when that ticket was purchased?
Yes, on September 27, 2017, and the timestamp is 4:52 in the afternoon.
So 4:52 p.m. on September 27th of 2017.
Yes, ma'am.
Can you tell us the passenger's name that appears on that ticket?
Yes, it's Scott Nelson.
Now, in order to purchase a ticket, and that has somebody's name on it, does the person who is purchasing the ticket have to provide an identification card?
Yes, a name and a government ID.
Government ID, okay. So, and is it the responsibility of the cashier who is selling the ticket to confirm that the person who's in the picture on the ID matches the person that is standing in front of them?
Correct.
I'll overrule the objection to that question.
So is it the responsibility of the cashier to confirm that the person that's in the government ID photo is the person who's purchasing the ticket?
Correct.
And then the name on the ID goes on to the ticket?
Correct.
Can you tell us what the travel itinerary was for this Amtrak train ride?
Yeah, yes, ma'am. It was on train 92 from Winter Park, Florida to Jacksonville, Florida.
And what time was that train scheduled to depart?
It was scheduled at 7:49 p.m.
Now, did something happen that day on the train tracks here in Orlando?
Yes, there was a double homicide in front of the trains in Winter Park.
All right.
Or not a homicide, a suicide.
Suicide, thank you. Okay. So did that delay that train?
Roughly about 3 hours.
Okay. So the train departed the Winter Park train station about 3 hours late?
Yes, ma'am.
Now, as part of your role as a detective with the Amtrak Police Department, are you involved in the collection of surveillance footage?
Yes, ma'am.
And with respect to, can you tell us where this, it started in Winter Park. Can you tell us where it ended?
The train ended in Jacksonville.
And can you tell us the address where it ended in Jacksonville?
3570 Clifford Lane.
And prior to were you requested by law enforcement back in 2017 to look at video at that train station that you just described for us in Jacksonville?
Yes, ma'am.
And were you given a person of interest to look for in the video from that day?
Yes, ma'am.
Now, that train would have actually arrived, you said, how long is that train ride? Do you know?
Not off the top of my head. I think it arrived somewhere around 1:40, 1:50 a.m. in the morning.
Okay, so that would have been on the morning of September 28th?
Correct.
And were you able to locate surveillance images of interest to law enforcement?
Yes, ma'am.
Can you tell the members of the jury there are surveillance cameras in the Jacksonville train station?
Yes, ma'am. There's multiple cameras inside the station and outside the station. It's a specific to that station, and it's proprietary only at that station. The DVR's right there inside the station.
Okay, and you're familiar with how these cameras capture their images?
Yes, ma'am.
Are they capturing them 24/7, or is it motion detected?
We have some on the outside that are motion detective. Everything on the inside is 24/7.
Is it a little bit of an old security system, though?
Very old security system.
All right, so does it sometimes, do the images sometimes what we call lag? Sometimes they don't appear to be moving smoothly?
The recording time is done per second, so it's like one time per 4 seconds or 3 seconds.
All right, now, when you talk about that video and what Scott Nelson was doing, from my perspective, it's important evidence for the prosecution. Because we know if we get to a penalty phase, there'll be psychological experts talking about Scott Nelson and how, maybe he doesn't understand everything, or he's had a tough life, or he doesn't really realize it, or he can't see the world the way the rest of us do. However, very clear here, he's fleeing Orlando, okay? He's fleeing Orlando, and he's changing his clothes. To me, those are two huge facts for the prosecution, not only during the guilt phase, but also potentially during the penalty phase if we get there. Jasmine, what do you think?
I think that this does not look good for him. It definitely is evidence of a guilty mind state for him to have immediately boarded a train and went to Jacksonville.
Consciousness of guilt, and he knows what he's doing here. I mean, I don't know how the defense can get around this at any point of this case, whether it's the guilt phase or penalty phase if we get there, but this guy seems like any criminal would do, cover his tracks and get out of Dodge.
And I think to your point, Vinny, I think it's going to be particularly important because I believe we're going to get to the penalty phase. It's going to be particularly important when the prosecution shows what he was doing to cover his tracks, because as you know, the prosecution is going to point out that he killed the only witness to his crime in order to get to the death penalty. So they're going to show this is what he was doing. He was killing the only witness to his crime. He was changing his clothes. He was fleeing. He was trying to cover his tracks. And I think that sequence of events is going to be particularly important in the penalty phase.
And Judge, I look at where we think we're going in this case. And this is Judge Wilcott. I know we've got two judges here tonight, Judge Ashley Wilcott. The defense not really objecting a lot. Not a lot of cross-examination. What do you think about their strategy? Because there's potentially two parts to this trial.
Well, it's driving me a little crazy because I would like to see some objections to some of the leading questions that, quite frankly, are giving the witness the answer, like, oh, the videos were lagging. Oh, yes. That's first and foremost. Second of all, as cross, you want to make your 1 or 2 points and sit down. That's a good cross-examination. You don't want to just, put 100 questions to recount all the testimony again. I don't see them doing either of those things. So I think at some point there are 1 or 2 points they could have effectively made and probably should have made on his behalf, but haven't.
Especially if they're setting themselves up to really, really contradict some of this stuff in the penalty phase. They should be looking to play the long game and trying to make sure they're preparing for that penalty phase.
Judge Belvin Perry down in Orlando, your thoughts about the way prosecutors are trying this case and the way the defense is. It's not your typical defense, not a ton of objections, not a lot of cross-examination during this phase of the trial.
The defense attorney in this case I'm quite familiar with. His strategy is to save it all for the penalty phase. He knows that he is fighting a losing battle in the guilt-innocence phase, so he's trying to set it up as best as he can to try to save this guy's life, to keep him from being subject to getting a lethal injection. He's trying to save a few things, hopefully for mental mitigation, but he's going to have an uphill climb with that based upon the flight and the consciousness of guilt evidence that the state has put in this case. Basically, he has no defense. He's going to try to save it all to the ninth inning.
And Judge, do you think that part of what they're doing is trying to retain their own credibility as advocates in not fighting the usual fight that you see during the guilt phase and saving that fight and that battle for the penalty phase?
Vinny, you hit the nail on the head. They want to be able to have some credibility with this jury, to be able to get this jury to listen to them as to why they should choose life over death.
All right, folks, our 13th juror question tonight is all about that strategy we've been discussing. Is the defense's decision to do very little cross-examination a good strategy here during the guilt phase? Go to our Facebook page or Vinnie Politan Court TV on Facebook. Let us know yes or no. The results coming up.
How were you employed before you became?
Okay, so apparently I'm being told that power went out in the courtroom. So, of course, we're going to be waiting for that to be restored.
It was a bizarre scene because initially you had all the jury sitting there, you had Nelson sitting there, and we're all kind of in semi-darkness. We reported this yesterday that it happened during the opening statements where when he was basically introduced by the prosecutor and accused of killing Jennifer Fulford, he turned and winked at the family. He did it again today. This time, it was when we were getting prepped by the judge that the next witness was the medical examiner and that there were going to be autopsy photographs. And there I'm sitting behind him again, and he does it again. He turns and winks.
Quantify how much of an airway obstruction she would have had as a result of having duct tape wrapped around her mouth and nose.
I believe it would have been complete external airway obstruction, meaning it completely blocked her nose and mouth.
What is your opinion, to a reasonable degree of medical certainty, about Jennifer Fulford's cause of death?
The cause of death is stab wounds and asphyxia.
Have you reached an opinion to a reasonable degree of medical certainty about the manner of Jennifer Fulford's death?
Yes.
What is that opinion?
Homicide?
Did he say he had anything with him in the room so that you would not breach the entry there?
Yes, he advised that he had a gun and that he had a gun and we should not come in the room.
All right, let's take a look at those 13th juror results. Is the defense's decision to do very little cross-examination a good strategy? 51% of you said yes, 49% of you said no. So kind of split on that, which is interesting because in a normal case, under normal circumstances, I think overwhelmingly you would say no. But as everyone's been saying here, the defense perhaps saving their strongest arguments and their credibility when it's time to decide life or death if we get there. So really a strange day down at the courthouse between the blackout and the wink, and then you had the autopsy photos.